I'm Judy Risch, and until May of 2024, I was an attorney with the U.S. Department of Education Office for Civil Rights, and I was co-head of the National Digital Accessibility Team. And I left to go to private consulting, partly because I knew the Title II regs were coming, and I thought I could have more fun and do things that were more interesting to me by coming over to the private sector. So that's what I did. Um, but I'm still here, and I was recently at the department, and I worked on the Title II regs when they were in their process in the government. So I'm very familiar with them. I also worked on the HHS 504 regs and those types of things. But I was co-head of the National Digital Accessibility Team, which is what OCR, the U.S. Department of Ed, did for digital accessibility, and there are thousands of cases. They are amazing people. They do amazing work, and they are completely overwhelmed. So if you have something and it hasn't moved for a while, just be patient with them. Call if you need help. They're there to help you, and I'm here to help too. But I have to say they are overwhelmed. So I'm here to talk about the regulations. This is my bio information. I have to say this. This is not legal advice. I'm a consultant now. I am not an attorney. Well, I'm not in an attorney position anymore. So what we're gonna talk about today is the ADA in Section 504. I was scared because I knew Corey was presenting before me, and he and I have had many conversations on the regulations. And he had not talked much about them. I'm shocked how little it is because it's consuming most of my life these days. So ADA Section 504, there are two different laws, the interplay, current legal frameworks. Whatever I say today about the new regs does not mean you can do nothing for the next 2 to 3 years, depending on your entity size. You better be doing something. So what standards are out there, what's adopted, who the new regulations apply to. I'm going to talk about some things that I think surprise a lot of people if you haven't heard me talk about it already. The scope of coverage, what is covered? The future, what do I think is coming in the future for all of us in the digital accessibility space? Some quick resources and conclusions. I have things about like how to prepare and stuff. I don't feel like with this audience, I needed that. So I took that out. If that's something you need to have further conversation on, please reach out to me. But those slides may or may not be in the deck. I don't remember if I pulled them or not, but I'm not planning on talking about like how to start your accessibility journey. I think there have been a lot of other presentations covering that information. I want to get more into the regulatory requirements at this point. So there are two laws out there. The Americans with Disabilities Act from 1990 that has two different important provisions. There's Title II and Title III. Title II applies to public entities, our school districts, our public libraries, our water departments, our township municipal governments, the states, the public universities, all of that is Title II. That was created in 1990. There's also Section 504 of the Rehabilitation Act of 1973. We'll talk about 508 in a few minutes, I promise. Section 504 says if you take any federal money from whatever department, the Department of Education, where I worked, but it's also going to become important with Health and Human Services. It also is in housing and urban development, and apartments, and subsidized housing. In any of those kinds of entities, you cannot discriminate based on disability. The regulations for both of these laws are old. The 504 regs are pushing 50 years old because they came out a few years after the regulations. So that's the 504 regs. They are enforced by the agencies that give you the funding unless there's an agreement of some kind. So the U.S. Department of Ed gives lots of money to states for education, and it says you can't discriminate based on disability because you take that money in your entire educational program. It is not just in what the money is guaranteed for. ADA Title II says if you're a public entity, you can't discriminate. Title III, which is also out there in the ADA, says private entities can't discriminate and has some different legal standards out there also. There are like 5 parts to the ADA. One's on telecommunications, one is on employment. There are lots of other parts. For our discussions today, really only Title II and Title III matter. And I know people have heard lots about like tons of digital accessibility litigation. We call it the drive-by litigation. Lots of people talk about it. You know, a law firm comes by, looks at your website, then says someone came in and says your website's inaccessible and sues you, and that type of litigation. That is all in the Title III space. And as of now, no one has touched Title III for digital requirements. So we have Section 504, which is contingent on funding, and ADA by your public nature or a private business that's a place of public accommodation under Title II and Title III. I hope that makes some sense. So these laws all currently say you cannot discriminate against someone based on their disability. The laws, until very recently, have not been amended to say anything about the coverage of technology. That does not mean your technology does not need to be accessible to people with disabilities. There are broad non-discrimination requirements in them. So you cannot say, we don't have to make things accessible until the regs are amended. That does not mean that. It says, the regs say all programs, services, and activities operated by the recipient need to be accessible. That's the 504 language. The Title II and Title III language both say you cannot discriminate based on disability. And there is a whole bunch of language about substantially equivalent ease of use, effective communications, and a whole bunch of requirements out there that require accessibility today. It doesn't have to be strictly accessible. I use the analogy, it just needs to be usable. So it doesn't have to be pretty. It doesn't need to be the same experience, but it has to be able to get the same information and the same equally effective ease of use. So I'm a JD PhD. I use this example. When I did my PhD, I did a lot of work at 2 and 3 in the morning in my research. And it means everybody should be able to do the research at 2 or 3 in the morning if everyone can do it, everyone else can do it. It still needs to be usable. What it doesn't need to be today, unless you have a state law saying something different, it doesn't have to be strictly conformant to one of the standards out there. So that's where we are today, but that's not how it's going to stay. So let's just talk about what are the accessibility standards, because we have lots of things thrown around and people get confused. I've run into this since I've left the government. People are like, it's 508, it has to be 508. And I'm like, we're not putting in any document anywhere there has to be 508 compliance. It doesn't. Section 508 has been around for a while, for a while. In the late 90s, that was the first place with a clean, articulate standard of this is what accessibility means, was Section 508. And it had like 18 points. It was very user-friendly. It was very functional. It was a great first thing. And Section 508 says any technology or communications things the government procures, they need to be accessible and meet these standards. Because life has happened and the web content accessibility guidelines have become so prevalent, a few years ago, 508 was amended to make it WCAG 2.0 AA. So that's where the federal government is. They're not on 508 anymore. They're on WCAG 2.0 AA, except government also has provisions for when you acquire a mouse, a keyboard, a monitor, and all those types of things, a telephone, all that good stuff for accessibility. That is included in 508, and that is not covered by WCAG, so there are standards for that. So that is what 508 is. Way back when I was in grad school, in the very late 90s, early 2000s, I was in Wisconsin. At that time, they had adopted 508 and said all our technology needs to be meeting 508 because it was the only standard at that time. WCAG came along and surpassed that. So that's where we are with WCAG. So WCAG, everybody's using 2.0, 2.1, or 2.2. At least you really need to be at AA. And I think the last speaker said it right. You should be looking at components of AAA to guide your design, but I don't think they have to be absolutely part of it. You don't have to meet it. It's hard and they conflict. So that's where we're at with those. There is still WCAG 3.0, and don't quote me on this, but my suspicion is 3.0 is going to look an awful lot like where we are today. When I talked about before, it's got to be usable. It doesn't have to be strictly conformant. Unless you can articulate a barrier to access, it's not a problem. It's just, I think 3.0 is going to be a lot more fluid and a dynamic standard. I think 3.0 is going to be back where we are today. So we're going to have this, in the next few years, we're going to rush to get to 2.1, and then we're going to go back to where we are today. But that's okay. 3.0 isn't out yet. It's in draft. It's moving. It's changing. It's evolving. And I still think we're a few years away from 3.0 being out. I'm going to just take a quick breath on all of that and see if there are any questions. I saw some things popping in the chat, but I can't see the chat on my screen right now.
Judy, there was one question, just I think looking for some clarification between Title II and Title III, and just the kind of the context maybe for the lawsuits in Title III right now.
Okay, so Title II is public entity. Title III is private entity. Depending on, this is where things get a little different and complicated and the lawyers get involved. Depending on state law, there become the rights to attorney's fees, and also there's rights to attorney's fees also under Title II and Title III. But the damages under Title III are more and greater. And so it's a better place to be litigating if you're not litigating for the right reasons. If you're litigating to make money rather than to make people to get accessible websites. So that's why the Title III litigation has exploded. California, like there are websites that track the federal laws, and the federal litigation, and it's focused in very specific places. It's New York, Florida, and California, and it has to do with the state law and the way damage recovery works. It's like the California stuff has fallen off, but it's a lot in state court, so we don't know what it is really. It's like New York, California, and Florida all have hundreds and hundreds of lawsuits. Pennsylvania, I believe, is fourth or fifth with like 80. It drops off very fast because our state laws don't provide as well. So that's where we're at in the Title III litigation. And that's why the litigation is the way it is. And there's not much else to say on that. It's just its own Wild West. It's a sad area to me, and it's very depressing because it's not about getting your site accessible. It's about getting your error reports to zero so that the drive-by litigation you don't get hit with it, but it's still not making sites accessible. So I think the more nefarious overlay companies have figured this out, though there's also litigation in that space, but that's where we're at. I hope that helps. It just has to do with state law conflicts.
Yeah, that was great. There's one other relevant question if you want to answer it now, then maybe we'll queue up some more for towards the end.
Yeah.
The question is, do the 508 standards essentially become obsolete under the new Title II regs if we are subject to both?
That's a great question. Generally, people aren't subject to both unless you're the federal government. Everyone's like, oh, if we take federal money, it's subject to 508. If we take federal money, it's subject to 508. That is not true. It is only if you are doing something on behalf of the federal government that it's subject to 508. So for example, when I was at the Department of Ed, another division of the Department of Ed had a nonprofit doing their website on doing a website for the Department of Ed on some statistics. So to make sure that is subject to 508 because it's being done on behalf of the federal government. If you are just doing it with federal funding, it does not mean you have to be 508 compliant. And that is a very big misperception. So that's why I'm always important to make sure it's there. So that's that piece of it. So that's where we are. So now that is where we are today. In April, the world changed, totally changed. We knew there were draft regs. There are April and May, actually. There are two different digital accessibility regulations coming out of the federal government that are super important. Everybody's paying attention to the Title II regs. I'm fully aware of them. I'd love to talk about them. We're going to talk about them today. There is a second set of regulation that's super important that no one's paying attention to or not taking seriously, and that is the 504 regulations of the Department of Health and Human Services amendments. They also updated their regs, and they have the same provisions as Title II, but the impact blows my mind when I sit down and think about it. So we're going to talk about Title II, which is public entity. And that's the easy one because everybody's aware of this. But I really am hearing lots of crazy stuff in the healthcare space about the 504 regs. So I want to talk about that and make sure everybody's clear on the 504 reg piece because it's super important also. And I think I'm really concerned people aren't paying attention. And while I think everything should be accessible, the healthcare stuff I find absolutely critical to be accessible. We learned in 2021 when the COVID vaccines were going on, they were inaccessible. We learned that telehealth was inaccessible. All of those things were inaccessible, and those are critical for privacy and other things that need to be accessible. So it's absolutely an area we need to be talking about and thinking about. And it is something that there are legal requirements coming the same way they're coming for Title II. So let's talk about Title II. There are 3 groups of entities out there. People always say, oh, my university is only 20,000 people. We have 3 years. No. You're at a state university that covers the whole state. You are absolutely not in that group. The size requirements in Title II say entities that go from 0 to 49,999 people don't have to be compliant to April 26, 2027. That is townships that are smaller, villages, and things like that. There are some counties out there, probably about 30% of counties, 40% of counties out there will fall in this group. Almost every higher education entity falls in the latter. I think 5 to 10% fall into this 50,000 and under. I'm just going to say to make my life easier group. The special district governments are these weird entities that are like cover very small things. They also don't have to be compliant to April 26, 2027. This is one of those, you know it if you are one, and if you don't know what it is and you're not it, you're not in it. So just that's not what I want to worry about. Everybody with over 50,000 in population is April 24th, 2026. So when I say a university, we look at the community you serve, the state you're serving. If it's a community college, we're looking at the county or counties or the region you're serving. I was working with a community college system. They have about 58 community colleges, and they had 6. 6 of them they fell into the small population group, but 3 of those said on their website, but a lot of our students are from across the state because we have a large virtual presence, which then bumps them back over into the larger group. And they were at like 45 or 48,000 population serving to begin with, if you looked only at their county sizes. So you're very few entities, except for townships, municipalities, and things, are falling in this under 50,000 grouping where they don't have to be compliant to April 26, 2027. Everybody else is April 24th, 2026. So I hope that makes some sense. So that is the Title II requirement and who has to be compliant. Section 504 and the HHS requirements are more interesting, and everyone's like, oh, this is easy. This is so not easy. The simple answer is if you have 15 or more employees, you have to be compliant by May 11th, 2026. It says in the regulation, a recipient is any state political subdivision, any instrumentality of the state political subdivision, any public or private agencies, institution, organization, other entity, or any other person to which federal assistance is extended directly or through another recipient, including any successor, assignee, transferee, or recipient, but excluding the ultimate beneficiary of assistance. So it basically means the ultimate beneficiary assistance being the citizen using the products is the person. So why I talk so much about this. So of course, healthcare and accessibility of healthcare, but this is bigger than that. So and we're going to talk about the next slide is, I believe, the Civil Restoration Act of 1987, which are like, why would this matter to me? The Civil Rights Restoration Act of 1987 was a response to a Supreme Court decision that said it was Title IX litigation, but it's extended to all these regulations, all these laws that said it was Grove City versus Bell. And that court decision said, kind of crazy, it only was, you had to like pinpoint where the funding went. You drilled very down. So if it was a grant and it was supposed to be on molecular biology, it's only that molecular biology department that's covered by this grant. The Congress said no, that is absolutely not the case. They went back in and amended it and wrote the Civil Rights Restoration Act of 1987, which says, and I took out chunks, but just for this part of it, it defines a phrase program activity to mean the term program to mean all of the operations of the following entities, any part of which is extended federal financial assistance. So a college, university, other post-secondary institutions, or public system of higher education, a local educational agency, system of vocational rehabilitation, or other school system, and corporation, partnership, or other private organization, states that such a term does not include operation of an entity which is controlled by a religious organization. So we're not going to worry about that part of it for now. So what does this Civil Rights Restoration Act mean for us? When we go back and look at the HHS regulation, it means that anybody receiving federal financial assistance from the Department of Health and Human Services, it means their entire programs need to be digitally accessible. The regulations apply to their entire program. What does that mean? So we have a private university and it has a hospital that's and the university and the hospital are both operated by the board of trustees of the same one board of trustees. There's one board of trustees operating a hospital and a university. Okay. The way the HHS money flows, if you look at usaspending.gov, it goes to the board of trustees. So that means, this is where my head gets exploding. Generally speaking, and this you've got to check with your lawyers, this is not a definitive because organizations are set up differently, means the money coming into the hospital that goes through the board of trustees means it triggers digital accessibility requirements over in the history department that have nothing to do with the hospital. So I'm saying that again. If you get money from HHS, and you don't even have to have a hospital, like we have universities that are private universities that are getting HHS grants for things like student mental health, that taking that money, and it's not a lot of money, it's like $250,000 for some of these schools, unless triggers digital accessibility requirements in academic programs. And it triggers digital accessibility everywhere. And I hope, does that make sense to everyone? And I hope your heads are all exploding, because when I realized this, I sat and my head exploded because I did not realize this is what it's going to mean. So what do the regulations require? Let's just start with, let's talk about this. So let's talk about what's required. Everything's covered, sort of. The regulations themselves say, whether you go through like the HHS regulation or the Title II reg, because those are the two digital regs out there, that the recipient shall ensure that the web content and mobile applications that the public entity provides or makes available directly or through contractual licensing or other arrangements comply with level A and level AA success criteria and conformance requirements specified in WCAG 2.1, unless the public entity can demonstrate that compliance with this section will result in a fundamental alteration in this nature of a service, program, or activity, or undue financial or administrative burdens. So it says here, and this is the part that's interesting, it's web content and mobile applications, which is not as broad reaching as I'd hoped. Um, HHS has a little more in it that we'll talk about in a second. So it's your websites and the mobile apps. That covers a lot, but it doesn't cover 100%. So like scientists who use some wild microscope in some university in their lab that is controlled by a program that sits on a computer, that is not covered here. So none of that's covered. It's what's on the web and mobile application. So let's use, for example, Zoom. We're on Zoom right now. Whatever platform I'm on is what I pick on today. Zoom has 3 separate presentations. There's a web-based Zoom, there's a program-based Zoom that sits on your computer, and there's a mobile-based Zoom. Technically, with the way this regulation's written, only the mobile and the web-based are covered. The program that sits on my computer is not covered. So those are the requirements under the Title II of the ADA for public entities. The 504 at HHS has an additional requirement, and I agree with it 100%. They also have a requirement for accessibility of kiosks in their regs. So if you get money from HHS, you also now have requirements for kiosks. This is really important because what we've heard is going on, and I agree with what's going on, is that someone would go to the lab to check in. All they'd have is the kiosk. It wasn't accessible. The person would stand there. 5 people would come in before them. They'd go in and see the doctor, go get their blood test drawn because it was a blood drawing center was where it happened, from what I've heard. Go get their blood drawn, and the person who's blind is still standing there waiting to check in. That's not acceptable. And so the regulations have requirements for kiosks. Now, in the hypothetical of you're a public or a private university, you happen to have HHS funding, you have kiosks in the cafeteria, for example. Are those covered? We think so. That's what we think is happening. This is all places we need to get clarity still. So, but that's where we're going on. Now that I've exploded everyone's heads, are there questions?
Judy, there have been a few kind of clarifying questions. If you're okay to maybe address some of these.
Sure.
First, just a clarification of what the accessibility guidelines are that need to be complied with in Section 504 HHS.
WCAG 2.1 AA. Also, the 504 regs and the HHS regs essentially look exactly the same. I'm sorry, the 504 regs from HHS and the Title II regs, sorry about that, look exactly the same. They're almost word for word similar. The HHS regulation harmonized a lot of Title II, so it has effective communication in it, it has the service animal provisions in it, all those types of things have also been adopted in the HHS regs.
Okay, great. Another question, just to clarify, for a state university, the size is considered based on the size of the state it serves and not the number of people at the university.
It's the population from where you're drawing from. So the state universities basically all fall in the April 26th, I think it's whatever 2026 date. The community colleges get a little more complicated because they're pulling from more regional things that could be smaller. Like I have seen community colleges pulling for communities that are only 30,000 with no real, they have online instruction for the classes that they have, but they're not doing like pure online instruction that's accessed across the state. So yeah, it's the state you're coming from, county you're coming from. For school districts, it's the students you serve. So if you're an open enrollment school that pulls students from across the state or from, a 6-county region, and even if your county where you're sitting is under 50,000, you are now in probably the 50,000 mark. If you look at all the counties in total that you're pulling from.
Okay, great. Another question, does web-based include LMS systems?
Yes. LMS, HR, I'm more concerned about HR, nursing, like, your healthcare systems, all of that. It covers everything. And there were provisions in the draft reg, and we'll talk about the exemptions in a minute or not, I don't care, that exempted the online instruction. and it does not exempt the online instruction. So if by some chance I'm old enough to remember when we had a program for the common LMS at the time, WebCT, there was actually like a program you downloaded to your computer and you went through a DOS. It was DOS. It was crazy. That itself was a separate program. It wasn't web-based. That might have been exempt, but haven't seen any that are like programs you download on your computer. But then it has a mobile app on your phone anyway, and that would create the requirements because you have the mobile app on the phone. So the LMS, and that's why there's provisions, and I'll go back in the regs that say available directly or through contractual or licensing requirements. Originally, the regs had like exemption for all third-party content. We were like, wait, time out. You can't do that because like so much of what education does is third party. And we're going to have a ton of programs that they're just like, oh, third party, we're exempt. And also, honestly, and I would advise people to do this too if it was the case, just have a third party host your website. It's over. And like manage your web pages and everything, and you're off the hook. That's not the intent of the ADA. That's not the intent of anti-discrimination law, and that wasn't the intent of these regs. So that hole was closed pretty tightly with the second round of regulations.
Great. Thank you. Another question, what is the deadline for a private university in the USA?
As of now, well, it depends. If you have HHS funding, it's May of 2026. May 11th, I think, is the date. If you have 15 or more employees, there's no university that doesn't have 15 or more employees. That's kind of not an issue. It'd just be some doctor's offices that aren't in that group. They're in a 2027 group. If you don't have any HHS funding, you can sit around and watch this all play out, because we're not there. It hasn't been adopted yet for you. But yet being the keywords, we'll talk more about that in a bit.
Okay, and maybe one more, actually a couple questions about enforcement. What happens if an entity is not compliant? Does it open them up to the possibility of a lawsuit rather than the government trying to ensure compliance? Maybe speak to that, and then we'll let you get back to your presentation. We'll get some more at the end.
Sure. I absolutely think it opens you up to a lawsuit. I think litigation, litigation is always a risk. I think you're open to a lawsuit today. I don't think if you've been ignoring it and you have and there's wide variance of accessibility of websites out there. I think they're inaccessible. Like, I think there's problem. You're open to a lawsuit today. We've seen the litigation. Generally speaking, in the education space, which is where I'm focused on, but I know in other spaces too, that's not 100% true. But in the education space, the litigation has not been about the actual entity's websites. It's about supplemental instructional sites. Was it the textbooks or other online instructional kind of things? Lab simulations and things like that have been the place of a lot of litigation. So I'd be more concerned about the litigation is a huge issue. Once the regulation standard is adopted, I think it's going to be a free-for-all. And I don't know how the automated checking component is going to play in, because people really like to show you, and I hope everyone here knows this, and I know like the WebAIM people, and I've had these conversations over the years, people love to just run an automated checker and be like, your website's inaccessible. And like, the automated checker is like, there's some stuff the automated checker can show you it does show you in an accessible website, but other things it doesn't. And so it's not accessible. Like it's going to be the drive-by litigation is going to explode, I think, potentially in this area. The only saving grace, I think, in the education space is that the money's not there. Where I'd be really scared is over on the healthcare side. And I think people aren't taking these regs seriously. I've heard things from hospitals saying, oh, it's all fine. Our public website's fine. And it's like, it's not your website. Like, and these are high execs at hospitals I've talked to. I've heard hospitals tell people like, these regs are optional. Oh, there's been the Supreme Court activity. They're not going to happen. And like, we don't know if the Supreme Court is going to strike these laws. And I'm not convinced that the way the court ruled in the Chevron deference cases, I'm not convinced that that the disability laws are dead in the water the way some people out there who don't want to comply with these regulations think they are. the the simple version is the regulations for 504 and the ADA have both been in front of Congress multiple times for amendments. We had the Civil Rights Restoration Act of 1987, where they saw the regulations that are in effect at the Department of Ed now. They had the Civil Rights Restoration Act in the early 2000s, where the Supreme Court, where Congress saw what Justice was doing, and they're like, yeah, you're doing a good job, but the court's hamstringing you and changing things. So Congress has acted since the regulations have been out. So if Congress disagreed with the regulations, I think they could have acted, and they have. So there is some ability that the regulations may not be as dead as people think or hope they are, because they don't want to comply with these provisions now. It'll be interesting to watch, but I'm optimistic that there is still a requirement for accessibility. And there's a whole bunch of other reasons, and I don't need to convince anyone here, but like, it's the right thing to do. And there are state laws coming up all the time, and Congress is going to act at some point. If like these regs get struck, Congress will act at some point to make requirements for this. We'll talk about this in a bit, but there have been some proposed bills along the way. So yeah, and I can't stress this enough. It also applies to all your vendors and all your third-party content. So, well, not 100% your third-party content, but your vendor things it applies to. Is there more? You want me to keep going?
There's lots of questions, but why don't you continue and we'll get some towards the end.
Sure. I'm going to just go through this pretty quickly because I think everybody knows this. There are a whole lot of exemptions. There are several exemptions. They've changed, the exemptions have evolved since the draft regs. I have heard anecdotally, there are some people out there saying, oh, learning management content is exempt. We have 5 days to make it accessible. And that's not true at all. It's absolutely not true. So there's an exemption. There's 2 exemptions that are next to each other that I think should just be one for all of our sanity. But there is archived web content exemption and then pre-existing conventional electronic documents. So both of these exemptions apply to the things that are old and that are archived off and put in a designated space to be archived. So your, water quality report from 1998, it's inaccessible as long as you say you haven't touched it recently, it's old, you can mark it archived, you can put it off, it is exempt. So it's everything created before the deadline, and it's created before the deadline and really not used. Now, if someone sees a typo in it on May 1st, 2026, and you're a Title II entity and someone sees a typo in it and they go and change that typo, I hope they enjoy making the whole thing accessible. Because if you've touched it in any way, shape, or form, it does trigger all the requirements of accessibility. So we're really looking at those old things that we've archived off and we're not using anymore. So if we had a class, for example, in a learning management system that an instructor has retired and is no longer there, that could be archived off and you're not using it. It's not current, so it doesn't need to be made accessible. Really, for archived documents, you still need to provide access to this information under Title II, effective communication. In HHS also, there's still requirements of that. So this is not like a get out of jail free card of we've created a whole bunch of inaccessible content today. We still have to have program access to the programs. It's a standard like today, but for those old board minutes and those types of things, we don't have to go back in and make them accessible unless someone makes a request for it. So that's the archive web content and pre-existing electronic documents. Third-party content posted by a third party, not posting due to contractual licensing or other arrangements with a public entity. And HHS has these exemptions also. This is what this really was intended was justice is a bunch of lawyers, and I get it. I agree. I get it. I get what they're saying. And courts get documents uploaded by attorneys all the time, and some attorneys just don't get accessibility. And they were concerned about someone like scanning a document, a current filing, and scanning it and uploading it to a court website and it being posted publicly and it being inaccessible. That was what they were really concerned about. And so they've gone ahead and there's an exemption for this. It is not a broad exemption. It is like for a lawyer who's uploading something, or if you have a chat board, like a chat board in a community that's based on a community's homepage, on a community's website, the third parties, um, the how do we even explain this? It gets weird. Like if someone posts something and it's inaccessible and it's just a member of the community, it's not, they're not held responsible for that. That's what this was getting at. So it's just that type of thing. It's not a big exception. It's pretty narrow. I can guarantee this is going to be an area of litigation. I have already heard there are great questions. I don't have great answers at this point. But remember, there's still effective communication. So we'll roll with that. The next piece is password protected individualized documents. There's such as bills. Water bills is the big one they talk about. This concerns me because it also is in the HHS regulations, because if the blood were, and this is like PDF, this is electronic document. So if your blood test results come back as an electronic document, do they now not need to be made accessible for someone who needs it? That really concerns me. I have real concerns about that one. So that will be an interesting one to see how that plays out over time. And there is finally an exemption also for pre-existing social media posts. You don't have to go back and make accessible your Facebook, your Happy Holidays Facebook post from 2020. That is not what is needed here. Those are exempt. But if something is germane to your program, service, or activity, it still needs to be accessible. That doesn't get you off the hook there. So remember, you still have effective communication. You still have requirements today. And if it's like really important to the program, service, or activity, you can't. It has to be accessible for these carve outs. And then the last thing I have on this is at the end of the regulation, there is a regulatory safe harbor, I call it. It says that if for some reason it's like, this is a defense, but if it's like technically not compliant, like you're getting an error, you're getting the error on an automated checker, but there's no barrier to access. You can still get the same information. You can still engage in the same interactions. You can conduct the same transactions, and you can do it in the same like ease of use. And it's the same experience. It just happens to be a little technical error. It's okay. That's all this is saying. So, this is a safe harbor. It's a defense. So someone can find you a violation, file a complaint, but then you can raise this defense of like, look, the person's right. There is something, this error is there technically, but it doesn't create a problem to use the product. So this is silly. It's that kind of defense out there, which is a really good thing because we have the drive-by litigation that just, there's stuff that like, I've seen OCR get complaints that just had no stating there was no violation if you actually read them. Now, if I go look at a website, of course I'm going to find something, but within the four walls of the paper, there was no actual barrier to access stated. It's very frustrating. So that is that piece of the regulation. And I'm almost done. I just want to talk about the future for a minute or two. A lot's going to depend on November. I'm not going to get into who and what. The Biden administration, Justice Department announced if there's it was back under Biden, but I assume this is going to stay, another Democratic administration, the Title III regulations, they'll adopt very similar regulations to the Title II regulations. So when someone asked, I'm a private university, when's my effective date? If you don't have HHS funding, it's coming. Like it's absolutely coming. I can guarantee it. The HUD has announced an intent, Housing and Urban Development has announced an intent to amend their regulations to have digital accessibility included in it also. So that's going to happen. There is Department of Ed at the exact same time that the ADA and HHS announced amendments to their regulations. Department of Ed announced the 504 regulation amendment. It hasn't come out. It's a year and a half late, I think, but I anticipate it'll look very similar to the HHS regs in terms of the digital accessibility components. I don't know anything about it. I did not see them when I was there, but they should come at some point, though I will fully acknowledge in the election cycle that it's not, the best move to bring anything out just because they're a lot of work inside for them to come in. And if there's a turnover in administration, it's for nothing. Um, so there's that piece. I'm going to skip this California bill for a second and talk about the Duckworth-Sarbanes-Sessions. It's dying. Tammy Duckworth in 2020, fall of 2022, announced a bill about accessibility of the vendors. I remember sitting around at a conference with a bunch of Fed people, and we were all like, why are they doing this? It's not going to ever pass anyway. It's the end of the session. It was really a consciousness awareness raising bill. Um, it got way more traction than expected. It has good points and bad. I don't know where the version is today. It was re-announced at the beginning of 2023, I think, with Duckworth, Sarbanes, and Sessions, a joint bill. I don't know if it's still around, but it is about accessibility of vendors. I don't think it's happening, but it is would be a nice way to get to our vendors, which I have intentionally not talked about today because we have lots of other sessions on that, and third-party vendors. So that's the federal legislation. Unfortunately, as of 2 weeks ago, it breaks my heart. California Bill AB 1757, I was my saving us all hope of a law. I know many, many people on this call know this, and I'm shocked I haven't gotten questions about it. The vendor accessibility is a never-ending problem, and third-party vendors are just really hard to get them to make things accessible, and they don't want to do it, and then you're responsible for it, and it's all just kind of a nightmare. The California Bill AB 1757, there were mixed reviews on it, but it was a potential bill in the state of California to hold the vendors responsible. So if X state university adopted a product and it was inaccessible, the university absolutely could sue the vendor, but actually the student who had the problem with the product could also sue the vendor directly. This could have saved us all. California is the 5th biggest economy in the world. No vendor is not working in California. It would have made a big difference very fast for the industry, because there really was direct litigation that could be brought against someone in only operating in the state of California, but it would make a big difference for everybody. The bill died in their appropriations committee a week or two ago, unfortunately. There was mixed reviews on the bill. I was optimistic about it. The newest version was actually fairly good. But it may be back next year. It has been floating around. Now this is the second year it's been floating around. So it is something worth watching. It's something worth, if you're in California, it's something worth talking about. But I think that really could have helped on, the products that are inaccessible, because we could go right to the companies and not through not the people using them, which would make a world of difference. And so that's that. So the Department of Health and Human Services, when they put out the regs, these are just links to their regs and stuff. The one that I really do like, and I find super, super helpful, if you haven't seen the Title II Small Entities Compliance Guide, even if you're a big entity, I find it super helpful. It kind of gives a little more of like the why behind the regs and stuff. There were a few spots where I needed a little more clarification, and they did a really good job on it. It's a nice little guide. I'm looking forward to seeing what else Justice brings out in the next few years. I will say, if you have questions on the Title II regs, it's annoying as anything. ADA.gov is an 800 number. You have to call the helpline. They don't have an email address, but if you call them and actually give them your questions, they say they're going to guide their guidance based on the questions that are coming in. So I can, I would strongly encourage people to use that, and call ADA.gov. I know it's annoying to pick up the phone. No one likes to do it, and I don't either. But I think if you have legitimate questions and stuff, that's absolutely fair, and I would definitely be using that. And that is the last. I did see going on in the chat somewhere along the way. Let me just stop sharing. The PowerPoint is not working with JAWS, and I'm very sorry about it. I will look at that as soon as we get off of here. And if the person just wants to shoot me a quick email, I'm jrish@grandriversolutions.com. I'll just shoot you the PowerPoint. I just don't love giving the free world my PowerPoints unless I have to. So, but I will definitely share it.
Yeah, there were quite a few questions about the slides. Yeah, there were some issues, and we provided a version that was had a watermark with it. And so yeah, if you can just folks want to
Excellent.
contact you, Judith, maybe you could type that your email into chat if you're okay to do
Abs-
that. That would give folks a way to do that and be ready for maybe a flood of emails. There are a lot of questions. I'm going to have to curate these in the 8 minutes that we have, but we'll try to get to at least some of these questions. First one. So, am I understanding correctly that for a state government, if your state health department accepts funding from HHS, then all state agencies are required to address 504?
I don't know. Like it depends how it is. I am a little, the state governments, the agencies are separate. So that would be like saying, I'm going to pick on Utah because Jared's here, but like the University of Utah takes money from HHS. That doesn't mean Utah State has to take that obligation. I think it's more confined to the entity within the umbrella. So the Department of Health is absolutely covered, but the Department of Transportation isn't. In the state government standard, it doesn't matter as much because we're all impacted by Title II.
Okay. And two related questions regarding really the applicability of these regulations outside the USA for companies maybe that work with US companies or multinational corporations whose internal systems aren't accessible, but the corporation does work for federal and state entities. Any thoughts on that applicability?
So it's what's going on in the US is absolutely covered. There's also, and I don't get into this because this is not my thing. Um, the there's the a European Act too that's requirements for everybody doing commerce in Europe. And that actually some people say is going to be more impactful than these regulations because it's all commerce. But I'm not up on European stuff because I try to only stay in the United States if I can avoid it. Easier travel.
Okay. There were several questions about third-party content. One example, I work in an academic state university library. We pay for a digital database from a private company for student and sometimes public use. Does that third-party private vendor have to be compliant? Also a question about whether the ADA rule applies to companies that sell products and services for higher education. I think that one's a little easier to answer. Um,
So I
and
think
yeah, just generally maybe some clarification around third party content.
so if you pay the third party money or there's any type of agreement, it is governed by a contract. And that means it's under a contractual relationship. That is absolutely third party content. So those library databases are absolutely required to be accessible. I have no doubt in my mind. Here's the good news. Here's the bad news. Library databases, I remember looking at them 10 years ago, 8 years ago, they were a disaster. They are much improved. This has been in the discourse in the library space for a long time. I love librarians. They all are all about getting people information. The people who taught me digital accessibility 20 years ago were librarians. They were the people who I thought were the first people in this space. So I think the librarians have been thinking about this and working on it. We've got a long road ahead of us and we have lots of things to do. But I think everything in the libraries is covered in the databases. If you have some weird database that is only available from X terminal in the physical library, I think you might be okay with providing someone a reader in that. But I think that's a very narrow thing, and nobody has X database only available from within the library. So the databases in the library are absolutely covered. And so I mean, it's going to be rough, but I think they've made really big improvements in the last 5 years from what I've seen.
Yeah. Okay, next question. Essentially, does this apply to social media platforms as well?
Yes, it says all old social media platform presentations are exempt, but no, the back ones are not. Like the new stuff isn't. The social media platforms, generally speaking, from what I know, are accessible. You are not responsible if the social media platform is inaccessible. So the Facebook is inaccessible, Twitter is inaccessible. X, um, Instagram is inaccessible. If it is inaccessible, you are not responsible for that. You are responsible for the content that you are putting on it.
Right. Okay, thank you. There were several questions about archived and old content. The first one is essentially, what if a document is old but not archived, like an old news article on a website?
So I think we try to get that stuff out and market archive to the extent we can. Um, with that said, the I always go by data analytics, data analytics, data analytics. Like if you have something that's only hit twice a year, just don't worry about it. Like not to not worry about it. Like I can't tell you, you've got to fix it. It's got to be accessible, but that is a very low risk proposition. And just stamp on it if you need access, contact us. If you have something that is getting a news article that gets 10,000 hits a month, I don't care if it's archived and old. It needs to be accessible because 10,000 hits a month is way too many to not make it accessible.
Okay. There were two questions just about like verification that these updates have been made. Will someone audit the online courses and websites, and then kind of a follow-up, like, well, basically, is it the entity itself, the school itself, or is this they're like external auditing and verification at the government level?
The government is not going to monitor this unless there's a complaint. So unless there's a complaint or litigation or a proactive compliance review. So we did, when I was at OCR, we opened 100 compliance reviews. On digital accessibility. I don't think that'll be happening anytime soon based on resources, but anything can happen. But it's nothing proactive by the government. So yes, this is a game, and there are people who are saying, we're just going to wait and see until we get sued or get in trouble until we make our stuff accessible. They're going to just do that. It's a bad idea. It's not highly discouraged. I don't think anyone here actually thinks that's appropriate. If you do, we probably should talk. Jared probably has a few words for you too. He's smiling at me, but I don't think waiting is the answer either. And I don't think thinking, oh, it's 2026 and waiting for it is the answer either. I don't think, and I think if it's a private university, you can say, look, it's not here for us right now, but it's going to be here for us in 5 years. I had guessed 2025 for many years. I had been saying 2025. I was off by a year, 2026. There's no predicting regulation, but it's here. Like there's nothing I can say. I have a community college system I've working with for 10 years. They're ready, but they have pressure points too. Their online classes are in good shape. They know where the problems are at the moment, but they're sitting there and they're like, so our HR systems are inaccessible. Like they have no idea what they're going to do. They hadn't thought about it. And all their policies, if you're really good and you are an early adopter and you're there and you did a great job, I'm proud of you. But here's the problem. All your policies are written for 2.0. Because if you've been working on it for 10 years, your policies are all written for 2.0. You need to go back in and rewrite everything. I actually would write for 2.2. I wouldn't even bother with 2.1 at this point. But that's your decision. But if you're really ahead of the game and you're sitting there like, oh, we're in great shape, we're not. I'm like, go check your policies because you're at 2.0 and you need to go back and update to 2.2 probably is where I'd go.